Peace, everybody. Peace, 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 peace. What's going on? What's going on? It's been a while. It's been a while. Yeah, I just wanted to come on here. In today's video, we're going to talk about when your creditors sue you instead of your debt collectors. Yeah, I was on this I was on Facebook, and I was like kind of looking at the chat rooms or whatever. What's this? And I was looking at the I was talking because I talk about debt collections a lot, as you know, and hold on. Yeah, I look at debt collections and stuff. Hold on, let's see my computer. But anyway, my computer was getting an update. That's the reason why I paused for a minute. But anyway, back on subject. I was reading some information on them little chat rooms, that you go into. And it was a chat room that I go into on, talk about debt collections and things like that. And somebody sent me a message about the creditors suing you, right? The creditors, the different, companies, they come in and they sue you and all that kind of stuff. Yes, that happens. That does happen. And, but, different banks, different companies, whatever, they do want to, come in and sue you for the debt. And the creditors, because these are your creditors, these are the ones that you signed up for, right? But it's kind of funny to me how they would sue you, but then they charged it off. See, something don't make sense to me. Now, I don't know everything. I don't know everything. I don't claim to know everything, and I'm trying to learn as much as I can learn to help as many people as I can help in this particular space, because people are going through it. Going into those chats, man, people, I'm talking about, we talking about people that's got like $20,000-$30,000 in debt, don't even know what to do, working, they got cars, and they're working with one car and hoping it don't clunk out on them and all that kind of stuff. It's really, really, it's diabolical. People are going through it, and people really needs help. So I don't claim to know everything. I just want to be able to know enough to be able to help people with their conditions, because it's stressful. I had one person say, all they did was pay debt. They never had a chance to eat out. They never had a chance to do that. All they do is paying debt. That's all they do. That's all they do is pay debt. And it's like, for me, I'm like, man, these folks is going through it. You kind of look back at your life, and when you listen to other stories, man, you got to take a second look at yourself. It's called checking yourself, because other people's situations is worse than yours. So you need to check yourself. And I literally had to check myself. You know, I mean, folks be going through it. But anyway, but that's my. But this is what I'm saying. You know, but and I'm not understanding. But I know I've digressed, but I'm back on subject. What I'm not understanding is, why is the creditor suing you when they're gonna get a tax write off? They're gonna get a tax write off. Why would they sue you? Why does debt collectors work with these creditors? I mean, I don't know. I really don't know. It's mind-boggling to me. Why would they sue you? Why would they sue you if they're gonna write it off? When they write it off, either they're gonna get a tax credit or they're gonna get a tax deduction. I don't know. I know a lot about taxes. I don't know what that, but I know it's going to be one of those two things when it goes on their report. When that 1099-C go down, when that 1099-C go down, I already know that's either what's going to happen. Either they're going to get credited, they're going to get a tax credit, that means money back, or they're going to get a tax deduction. That's still money, because that's money that they save. So my question is that, isn't that a double dip? Isn't that a double dip if they write it off, get a deduction, then still come after you for the debt? Isn't they double dipping? Not understanding that. I mean, I would imagine that they could do it, because I'm gonna tell you why I say that. I would imagine because if a debt junk buyer sues you for debts that they picked up for pennies on the dollar, then and you pay them, that creditor could legally come back after you. But now, could that creditor come back after you after they done charged it off? We're going to have to do some research. We must do some research. Let me see. Let's see. Let's try it. Let's do this. I says, okay, when can a creditor go after consumer after I'm just curious to know. Just curious to know. They say the company can. It says right here where I'm looking at. I done Google search this thing up, and it does says that a creditor can go after you. It says a company can still collect off on a charged off debt. Yeah, that says many still pursue and harass even after they done charged it off. They can. That's what it says here. Man, look, I just Google searched it. After 180 days, they normally write it off as a loss. See, that's what I'm saying. So, I mean, yeah, I mean, that's crazy. They still can come after you. They still can come after you. I mean, but I mean that's what it says here. Do I agree with it? No, no. In the idealistic world, you know what I'm saying? That should be going down. But it's true. They can go after. They can come after you. They can come after you for that charge off debt after over 180 days. Your creditor. You know, but and I'm like, and see, this is something that needs to be addressed because a lot of people don't know that. Like myself, I hold myself accountable for not knowing that. You know what I'm saying? Because I always thought that the debt collectors picks them up. Nah, that creditor still comes after you, like Capital One, or Discover, or Synchrony Bank, whatever. They all still come after your tail. You know what I'm saying? Because, like I said, it totally makes sense to me now. Because, like I said before, if if the debt junk buyer picks it up and they get a whip of it, they can come after you. Now you didn't pay twice. Now you pay. Now that's where the gray area is for me. For me, that's where that gray area is for me, and that's what my statement is. And I'm more so concerned about the debt junk buyer. In you understanding the platform that you give them when you pay them or you talk to them. LV&V and Midland Funding, Portfolio Recovery, and all these other different companies, they don't have a dog in your fight. They don't have a dog in your creditor's fight. They don't even know your creditor. They just doing business with them. The debt junk buyer business is a very lucrative business. Very lucrative. Very lucrative. Here, I got 10 files. All of them owe $2,000 a piece, right? And I pick it up for $200. All I need is about one or two. I'm paid off. I'm well paid off. Even if I just get $4,000, I done made some bread. Just think about it. If you got 10, that's at $2,000 a piece. You do the math on that one. And then here I come in as a debt junk buy for $200, and all I need is 2, maybe 3. And I made my money. See, but that's my problem with the debt junk buy. It's not that so much. It's the fact that the debt junk buyer don't have a dog in the fight, because a lot of people think that the debt collector is working with your creditor. You know what I'm saying? Do they have your wet ink signature? No, they don't. Do they own the debt? No, they don't. Because they got to prove all of that. That's my whole issue. I ain't talking about the creditor. You in trouble when you come with the creditor. I'm gonna sit here. I ain't gonna sit here and tell you no bull crap. You can't FDCP them or nothing, cause they got all your information. Now it's verified. Now what? Pay me. Pay me. I'm the holder in due course. I'm the creditor. I'm the holder in due course. The FDPC 15 USC 1692G can't save you. Not with that creditor. That's why I say handle your business. Now, can we negotiate? Yes. That's a whole nother monster when you have to deal with your creditor. You got to know how to look. You got to know how to negotiate, not beg. Negotiate. Negotiate. You know what I'm saying? There are some laws out there that can help you in this negotiation process. There's some laws out here that can protect you in this negotiation process. There might be something that your creditor may do wrong and you're protected. You know? But I'm telling you, but I mainly, like I said, my mainly focal point is that junk buyer. Because that junk buyer does a lot of shiesty stuff. And not all of them. Not all of them works within the same capacity of being shiesty, but they got shiesty, but they all do got some shiesty ways. Just existing is shiesty. Just because they think they slick. Because they use the law, they use the fact that you don't know what your rights are and you don't know the law, they're gonna get you. And this is why I harp on the debt collection situation faster than I do on just the regular creditor. You know what I'm saying? Because the creditor, they got all rights. They got all rights. You gotta negotiate with them. But the debt collectors, the debt junk buyers, no. No. They holders. They just holders of whatever little paperwork that they got. But the creditor is the holder in due course. Remember that. And you know, you're sitting around here, y'all, look here. I don't know what nobody else, other content people put out. But when reality sets in, you'll know what process works and what don't. I talk to my homeboy about this all the time. He said he got this friend up there with him. We call him, we got a nickname for him, call him Charlatan. Because he talked about all this, you know, he talked about all this and all of that, you know what I'm saying? And I call it sovereign citizen stuff. Let me tell you something. I'm going to be real. 100. I don't hear nobody saying nothing about this. Ain't none of this stuff written in stone. None of it. Even when you write a letter to the Fair Credit Reporting Act. Well, to the not the Fair Credit Reporting Act, but the consumer agencies. When you write a letter to Equifax, TransUnion, Experian, or any one of those third-party consumer agencies, it's not written in stone on how you write them. None of this stuff is written in stone. Yeah, they tell you, you know, write a letter, you know, requesting this, that, and this, but they don't tell you. But it's not written in stone on how to get around Oscar. Everybody's got their point of view. Everybody's going to help you. Going to say, this is the kind of wording you may use, but is it 100? No. This is the reason why they say, for all you credit repair companies, so-called, wink, all you so-called credit repair companies out there, I don't like that word. That's the reason why they say you cannot guarantee a result. You can't guarantee a result with this because it's not written in stone. Do you think them data furnishers want you to win? If you win all the ding dong time, they go out of business. It's their business for you not to win. It's their business for them to have that stuff on your credit. It's their business to share your information. How you can opt out. They don't tell you that you can opt. They tell you can opt out, but in the fine print. In the fine print, you have a right to opt out. You have a right to opt out from them sharing your information. Oh, but they don't tell you about the third party. LexisNexis, Innovis, Stream, CoreLogics, and all of them. They don't tell you about them third party data furnishers that shares your information, and that's how it's against the law on a permissible purpose. 15 U.S.C. 1681 B, permissible purpose. They don't tell you that. No. Bet you they ain't gonna put that in the fine print. But yeah, you can opt out on all of that because they're the data furnishers. They're the ones that's reporting the mess. LexisNexis. They're the ones reporting the bankruptcies. They're the ones that's scraping PESA and getting your bankruptcy and putting it on your report. Who gave them permission to do that? You did, because you acquiesced to it through your silence. So automatically they're going to furnish the data. You just shut them down. And all you schoolers, ones that's going to college and all these different schools, you need to freeze your accounts. Freeze it. And go on to all them companies, look them up. All the third-party consumer agencies, like I said, CoreLogics, SageStream, LexisNexis, go on to all of them. I mean, you can go onto the CFPB website and get those third-party consumer agencies and opt out from them reporting on your report. Especially that I was stinking one out there in California called LCI. Opt out of them reporting. Just like, for example, just like I'm finna drop some sauce on you. It's just like that bankruptcy. That bankruptcy normally is reported by LexisNexis. Well, I think what I know, I know with TransUnion, LCI had was reporting bankruptcies. Point is, they pick it up from PESA. What's that? The public access, I think it's the public access consumer electronic registry, something like that. But I think that's I can never think of the name of it. Let me see something. Let me see what the name of it is. See what the name of it is. What is the name of PESA? She said, what is the name of PACER for NCIE? Let's see. Let me do this. See. It says, what is the name of PSER reporting all right, see what it do. That's what it is. Public access to court electronic records. That's the name of it. That's the name of it. That's the name of it. You know what I'm saying? You know, so, but PACER has, that's that public access court electronic records company, and they get that information off of PACER. That's hearsay. That's hearsay. That can be fought. That's why that bankruptcy should not be on your report, because that's hearsay, and who told them to report that on your report? They got to remove it because they didn't have permissible purpose. They did not have permissible purpose to report that information on your consumer report. Did they? No, they didn't. Did they write you and tell you that they was going to report it? No, they didn't. Did you write them and tell them that they could report? No, you didn't. So what is all this junk about a bankruptcy being on your report, and it's how hard it is for you to get it off? Man, that's bullcrap. You can get that report off you can get that bankruptcy off your report, and it ain't gonna take you no damn 10 years. It is not gonna take you no 10 years. So don't be fooled by this mess. It's hearsay. But what we do, we're send 1 or 2 letters and give up. I'm a victim of it. I did it at one point. I didn't understand what I was doing at the time. But until when I seen that first letter, was Equifax or something, and this stuff come off the report, and I was like, confidence. When you get those removals, that builds your confidence. Damn, what else can I do? You be looking around. Man, what else can I do? You know? That builds your confidence. That's what this is about. That's what this is about. You know, and I'm telling you, and like I said, you stop listening to these doggone charlatans. Yo, because I'm going to tell you something right now. These charlatans going to run their mouths, but they ain't going to put one paperwork in. They going to come to somebody, they going to go to somebody, hey man, put this paperwork in for me. See what they do. You know what I'm saying? They ain't going to do nothing. They ain't going to sit at a desk and put no paperwork in. They ain't going to do none of that. They ain't going to look up the laws. They ain't going to see what's applicable in their state. Heck, I bet you don't even know what the statutory limitations on collecting on the debt is in their state. These charlatans. That's what I call them, charlatans. Sovereign citizen rhetoric that has no basis. They have no basis nowhere. It's based on nothing. Nothing. Because number one, just because you say it, that don't mean it's going to work. And when you say work, what does that really mean? What does that really mean? Is it going to work? Oh, so you can extinguish your debt. You can discharge this debt. What happens if you get pushback? How much do you know when you get that pushback? Man, y'all need to look. Y'all do what y'all want to do. Y'all do what y'all want to do. You know what I'm saying? I'm not going to debate nobody. I'm not going to, dispute anybody's information. Hey, that's your information. Because if your information that you put out there, you took time out to write, and you took time out to draw up paperwork, this, that, whatever, and you get a result, kudos to you. Kudos to you. Shout out to you, whoever you are. I have no problem with that. But what I'm merely talking about, back to what I was saying about these creditors and these debt collectors. You need to know the difference between when your tail is being sued, who's suing you. Look at your paperwork. Look at your paperwork thoroughly, quietly. Sit down and go through it line by line with a fine-tooth comb. And look at your paperwork. And look to see who is suing you. When you see that it's a debt collector suing you, Midland Funding, they suing you, you got to file an answer. But let me say this about that filing answer stuff and this summons stuff. Because I have first-hand knowledge of this. See, I'm telling you what I've been through. I'm not speaking about what I read on some doggone Facebook page or what some guru on YouTube spoke about. I got first-hand knowledge because I went through it. A lot of times when they send you a summons in that mail, it's because you didn't answer those letters. You did not answer those letters. They was doing an administrative process on you. You did not answer those letters. And it says, we're going to assume that the debt is valid. Now, my situation may be different. But I'm just speaking about my situation. I ignored the letters. I read them, but I didn't know that they was doing an administrative process on me. I didn't know they was doing an administrative process on me. But they will do an administrative process on you. It doesn't make a difference. It's a debt junk buyer, it's a creditor. I don't care if it's child support. They will do an administrative process on you. And then if you don't answer them, they got grounds. See, this what gives them this. See, this is what I'm saying. They don't willy-nilly this. Because they have to have proof for bringing you into court. Because they're the ones that's got to assert it. They're the ones that have to assert. It's the one who asserts, not the one who denies that's got to prove this case. How are they going to assert anything when they ain't got no proof? Come on, y'all. Pay attention. I'm telling you what I know, not what someone said. They got to have proof. If they don't have proof, they ain't got no standing in court. See, they'll send you a summons. They may know. They may send you a summons and know you're going to stick your head in the sand like an ostrich. And they're going to automatically win by default because you're going to go into dishonor by not showing up. But all in all, if your creditor sends you, put a summons in the mail, it's because they done sent you letters. If that debt collector that junk buyer is gonna put a summons in the mail, they done sent you letters. They gotta prove their case. They gotta prove their case. If they ain't got nothing to show that they was trying to correspond with you and you didn't answer them, they gonna lose. They gonna lose. I don't care if it's a creditor, and I don't care if it's a debt collector or a debt junk buyer. I don't care what it is. If they can't prove it, that they was trying to get in contact with you. Yo, we sent them this letter, we sent them that letter, we sent them this letter, we sent them that letter. On this date, that date, this date, that date, this date, that date. They got you. Now they got their case, that they built their case upon on you. This is what I'm saying. This is what I'm trying to talk to the people in them chat rooms. They can't do anything unless they can prove their case. If I don't know what it is in other states, but I know in the state of Mississippi, when the sheriff comes to your house and they put a summons in they put the summons in the hand of a person over the age of 18 years old that lives in your house. If it's for you, even if it's for you, they got to be over the age of 18, and that's the rules. I know that I'm speaking for the state of Mississippi. I'm telling you. But I don't care what state you're in. If you get a summons to come to court or a certified letter to come to court, or however the process is for them to get you to come into court, you're gonna have to answer. You're gonna have to answer them. But if they ain't got no proof, I don't care what state you're in. If they ain't got no proof to bring you into court, and you go into court, the judge's gonna dismiss that case. They got to have proof. Anyway. It's Friday. This is Juneteenth. I had to bring you a video because, like I said, it had been on my mind. I hadn't talked to you guys since last week, and but we're gonna talk to you guys probably tomorrow. I'll probably put out another video tomorrow, and I'm gonna be doing another series on this debt collection stuff. You know, because like I said, this thing has got to go, because I see a lot of people that need help, and I want to be able to help people in a mighty way. You know what I'm saying? If you can't give your information out for free, then you don't know enough. Because sometimes people need immediate help. I ain't talking about the help that you ordinarily give people, whatever, just that. No, some folks need help right then. Right then. Straight up. So, and that's where we come in at, and we commence to doing, and we're gonna continue doing it. So, hey, this is the Blind Intelligence channel. I'm your host, Foresight. And thanks for watching.